Hello and welcome to Bite Size Legal, where we tackle legal issues one bite at a time. My name is Drew Jenkins and I'm an attorney licensed in Georgia and Alabama. And today we're going to briefly discuss the 3 disclosure documents that you may receive at a closing. If you closed a house in a residential transaction prior to 2015, you probably remember the form called a HUD-1. The HUD-1 is the document that disclosed all of the fees that were both paid and earned during the closing. Now, that form could be a little bit difficult to read. There were a lot of, we'll call them strange rules regarding about roll-up lines, particularly line 1101, where certain fees were not disclosed directly, and so you may have actually had an addenda attached to the end of your HUD-1 that disclosed the breakdown of the fees in line 1101. In addition to that, you also received a second document known as the Truth in Lending Act. It looked a lot like if you were to go and finance the purchase of a car that broke down the interest that would be paid over the life of the loan as well as certain terms of the loan. Well, the government decided that it was a bit silly to use 2 different documents to disclose it, and that certain roll-up lines, such as 1101 in the original HUD-1, made it more difficult for consumers to understand the totality of their transaction. So they passed a law known as TRID, which stood for the TILA-RESPA Integrated Disclosure. TILA, of course, stands for Truth in Lending Act, and RESPA is Real Estate Settlement Procedures Act. So if you want to know the full name of the TRID bill, it's actually the Truth in Lending Act, Real Estate Settlement Procedures Act Integrated Disclosure, which is what gave us our current closing disclosure. Even though it solved a lot of problems the HUD-1 had, it has also created its own set of problems. If since 2015 you have purchased a home in a residential transaction, you have been governed under the new laws and you received a 5-page closing disclosure. In addition to your seller received a multi-page disclosure as well, probably known as a seller disclosure. And the question is, well, why did we feel the need to split it into 2 documents instead of 1? The whole point of a disclosure is to disclose the breakdown of fees in the real estate transaction. Well, that's because, like the old TILA form, it contains certain information that under Regulation P, as opposed to Regulations Z and X, see how nice and easy this is when dealing with government regulations. In reality, what happened is there's certain information that the government considers private, and that has to do with certain loan information, loan account numbers, things of that nature. And only the borrower or the consumer, who is the protected party under the TRID laws, are allowed to see that. That's why your borrower's closing disclosure is 5 pages long. It integrates what used to be on the old TILA, which is how much interest you're paying over the life of the loan, certain information regarding the loan, interest rate, loan numbers, things of that nature, in addition to all of the fees that are paid in closing. Now, given that that loan information is considered non-public information, sometimes also called non-public private information or non-public personal information, depending on how a particular creditor wants to word it, the seller is not allowed to see that. So we had to create a separate document, which the government did, that's known as the seller CD. And the seller CD does not disclose any of the borrower side of the transaction, but only the seller side of the transaction. Whereas the seller side of the transaction should disclose some of the borrower side of the transaction. Even though in general, I do believe that the closing disclosure is worlds easier to read than the old HUD-1, it has introduced its own problems in the sense that now, if you're the seller especially, you don't actually know how much was paid in a closing. You know the portions that you were responsible for, and the borrower knows the portion that they were responsible for, but depending on the particular lender involved, the borrower CD may not disclose the seller's numbers, even though they should under the amendment to the regulations that were passed, and also in 2015. So you still don't know how much is actually paid in closing. So what form do you want? You want what is called the settlement statement. The settlement statement is not a document that is generated by the government. It is something that almost anyone's software can generate and is typically used in commercial transactions. It is my opinion that the original settlement statements are actually the easiest of all to read. They're made up of essentially 5 columns. The left-hand side belongs to the borrower, and the right-hand side belongs to the seller, and in the middle they tell you what the particular charge is for. It breaks down purchase price, it breaks down your prorations, your payoffs, and itemizes all of the fees that are paid in closing. So it is a very simple document that can be seen. Now, if you're a real estate agent and you're trying to look out for your clients to know how much they're paying, typically in real estate transactions these days, you're going to get a copy of the seller CD. It's the simplest one. It's still fuzzy regarding who can actually receive the combined CD. The CFPB, the Consumer Financial Protection Bureau, that is in charge of enforcing TRID, actually passed on the opportunity to elucidate or to let us understand who can actually receive a combined CD. Parts of the regulations say that all the parties are supposed to see it. Other parts of the regulations say no, only the borrower, because it contains, again, some of that non-public information. You also have the Gramm-Leach-Bliley Act, as well as Regulation P and state privacy laws that get involved. So really what you should be asking for as the realtor or even as one of the parties is, hey, I want to know how much was paid in total and I want to see the breakdown. And the document that's going to give you that is called the settlement statement. Now, is the HUD-1 still in use? Yes, it is. Sometimes you'll see in commercial transactions, also in reverse mortgages, the HUD-1 is the document that's mandated to be used. But in most consumer, residential, or consumer transactions, which is defined as residential transactions, you are going to be using the new closing disclosure. Now, if you do subordinate loans that meet certain criteria or government loans, you will also still receive the old HUD-1. Again, that was a lot to fit in today, but I hope you found this little bite useful. So remember, when you're closing, you're going to get the CD. Ask for a settlement statement to see the whole picture. If it is certain kinds of transactions, you might still receive the old HUD-1. Again, ask for the settlement statement to see the whole picture, and you should be able to receive it. Always ask questions if you see any fees you don't understand. That you're paying for it one way or another, so you should know what it is. Thank you for joining us today, and again, if you have any questions or comments, please leave them below if you're watching on YouTube. If you're watching on WeChat, just leave it in the thread that is received, and we'll see you next week. Thank you.